having the president of the Law Society of Kenya, Charles Kanjama, to delve into this matter without political nuances and biases. Once again, welcome to NTV Tonight. My name is Dan Mwangi alongside David Agondoa, who is on the sign language interpretation. Now, in a lengthy judgment delivered by a three-judge bench comprising Justices Eric Ogolla, Anthony Mrima, and Frida Mugambi, former Deputy President Rigathi Gachagua suffered a major setback after the court dismissed several of the key issues he had raised in his petition challenging his impeachment. The judges found that both the National Assembly and the Senate acted within the law in conducting public participation during the impeachment. The court further held that alleged political biases on the part of the speakers of the two houses and members of parliament could not, on their own, disqualify them from carrying out their constitutional duties or interpreting the law. The bench also ruled that the nomination and subsequent swearing in of Professor Kithure Kindiki as Deputy President did not require the existence of a fully constituted Independent Electoral and Boundaries Commission, IEBC.
The responses filed, the submissions of counsel, and following our deliberations and analysis, we now pronounce ourselves on the issues presented. On jurisdiction, we hold that the impeachment proceedings challenged herein are justiciable. This court possesses jurisdiction under Articles 22, 23, and 165 of the Constitution to determine whether the National Assembly and the Senate acted within constitutional bounds, complied with constitutional procedures, respected constitutional rights, and remained faithful to the constitutional safeguards governing the impeachment of a deputy president. On allegations of bias, the allegations of bias, predetermination, and conflict of interest advanced against the speakers, members of parliament, and senators are unsubstantiated. They rest on political inference and suspicion rather than objective evidence capable of satisfying the required threshold. On public participation, we are satisfied that the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua met the constitutional threshold. The Senate did not violate Articles 10 or 118 by failure to conduct its own independent public participation. We further hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149, Sub-Article 1. Constitutionality and legality of standing orders. We find and hold that the impugned standing orders of the Senate and the National Assembly are not unconstitutional. Composition of the National Assembly, role of IEBC, and nomination of the Deputy President. We find that while the failure by Parliament to enact legislation on the gender rule remains a constitutional concern, this court has recently clarified in the Conchella and others decision that the remedy under Article 261 is still available and must be pursued through the proper procedural channels. Consequently, it would be premature to hold that the National Assembly was improperly constituted for purposes of considering the impeachment motion. We find that no input or intervention by the IEBC was constitutionally required in the midterm replacement process under Article 149, Sub-Article 1. The absence of IEBC involvement did therefore not render the nomination or filling of the vacancy unconstitutional. The gazettement of the Senate resolution, the President's nomination of His Excellency Kindiki, and the National Assembly's approval did not contravene the Constitution merely because they were undertaken expeditiously. We therefore affirm that the nomination and appointment of His Excellency Kindiki as Deputy President was valid. Constitutional processes. We find that Parliament ought to urgently enact a dedicated statutory framework for the removal of the Deputy President under Article 150. The phrase, in quote, with the necessary modifications, is a substantive constitutional directive requiring Parliament to adapt the presidential removal framework to the distinct constitutional position of the Deputy President. However, the absence of such legislation does not vitiate the impeachment process already undertaken. We further hold that under Article 145, the Senate was at liberty to conduct the trial either by way of plenary or through special committee. The right to fair trial under Article 47 and Article 50, we find that His Excellency Gachagua's rights were infringed when the Senate declined to allow an adjournment. This violation constitutes both a vindication of his rights and a recognition of the constitutional infirmity in the process, but does not undo the impeachment itself, given the finality of Article 145, sub-Article 7, and the constitutional absurdity that would arise from dual incumbency. The Constitution is the grundnorm, and where that grundnorm deliberately and unequivocally withholds authority from the court, such limitation must be respected.
And that is the summary of the judgment of the court, that's the High Court, which was giving its verdict on the petition which was put in by Rigathi Gachagua on his impeachment in 2024. And like we said, we shall be following up because there already are commitments to appeal the decision. And we've seen that one of the sticky issues here is about whether the decision stands in light of the admission that